Hi, I'm Fiona Henderson. I'm in Albany this week instructing counsel in a white-collar crime matter, and I thought I would take the chance to answer one of the most frequent questions that I get asked by my European clients and by European lawyers. What is the difference between a barrister or counsel and a solicitor? Unlike most jurisdictions around the world, the UK is an exception. Australia still operates by and large as a split profession. Barristers are specialist independent advocates who act as the mouthpiece of the client before the court. Solicitors, usually operating as part of a firm, are the intermediary between the client and counsel, the client and the opponent, and the client and the witnesses. Solicitors carry out the nuts and bolts of transactions and the nuts and bolts of litigation. In litigation, they engage in marshalling the evidence, getting hold of all the relevant documents, contacting, locating all the relevant witnesses, and putting together the client's story behind the dispute, getting it into a form that it can be used in court and it can be presented in the best possible light. Solicitors instruct barristers to appear in court on behalf of their client. It is the solicitor who is the client of the barrister and who is responsible for the payment of the barrister's fees. There are a few barristers who will accept instructions directly from a client. That probably happens more often in criminal matters than in family law matters. Typically, a barrister will require to be instructed by a solicitor. Barristers are divided into junior and senior counsel. Senior counsel, or Queen's Counsel in the UK, have been recognised by their peers as having reached a level of seniority and expertise in their particular fields. Senior counsel typically are brought into large, complex pieces of litigation, often involving large amounts of money or very technical, specialised areas of law. They need to be cases that warrant the additional cost of having two barristers rather than just one. The best outcome for a client in a dispute is usually, in my experience, when a barrister and a solicitor work together from the outset of the matter. This allows an overall case strategy to be developed from the outset, and it allows the barrister to take ownership of the dispute and to have input into the development of that case strategy with a mind to how they're going to present the case to the court. It allows a barrister to get to know the client from the outset and to understand the strengths and weaknesses of the case and to work with the weaknesses and weave them into the case in a way that minimises their impact on the overall presentation of the case. Our firm has a pool of barristers who we work with throughout Australia. We bring them on board very early in a matter so as to have their input into ways to strengthen the client's position and deal with any weaknesses or gaps in the client's case at an early stage so that we can achieve the best possible outcome, either through a negotiated resolution or ultimately through having to bring the dispute before the court for resolution. Until next time.